tonight is no Julie. You've got Paul Peebles here with Old Capital. So I want to welcome everybody to Zoom at 8. My name is Paul Peebles, and I'm National Director for Old Capital Lending. You might have heard me on the Old Capital podcast, which is downloaded 60,000 times a month. So we are so glad that you made it. And Julie Peterson is on another due diligence assignment following Michael Becker. So she is out today. So you have me. So if you know, I've been in lending this is my 36th year. I've closed 5,800 apartment loans. And we do about $1 billion a year, a little bit over $1 billion, maybe $1.2 billion in apartment lending every year. And so that's a lot of loans. And we do that with a team of about 10 people. And so we are a relationship lender. And not only do we bring in the 70 to 80% of the money, we should be your best partner in these transactions. But we also help you source sponsors, attorneys, insurance brokers, limited partners. So if you're looking for something right now, please give the opportunity to give some feedback. And Julie's happy to help you with that. So tonight, we're going to do something a little bit different. So we're going to talk a little bit about syndications with a friend of ours that's been doing this for a long period of time. She's an attorney. So Kim, thanks for joining us. We certainly do appreciate that.
Hey, I'm happy to be here. Thank you for having me.
So Kim is a securities attorney. And a lot of people ask me, Paul, what is a securities attorney? I mean, there's a transactional attorney, kind of a real estate attorney that kind of goes through your contract. There is like tort law, people that sue you because you get in an accident or you fall down. What is a securities attorney? Can you kind of give me some definition on that, Kim?
So we help people who are raising money from private investors.
And so does it take a certain special skill level? Because when we talk about securities, we're really talking about most of the time federal rules, right?
That's right. So, it really just takes somebody with some intimate knowledge of the federal rules relating to raising private money that can, help you navigate those rules and make sure you don't get in trouble. So
if I was in a conversation, just a general conversation, I saw Kenneth Summers over there. Hey, Kenneth. Kenneth, I have an opportunity, and just between you and I, that my brother-in-law is a syndicator and he needs to raise some money. And he's told me that if I can collect $100,000 from you, can you afford $100,000 to put into his investment? And perhaps that I can make some money on this deal too? That's kind of a common question. Kim, is that legal to do something like that?
So what you're asking is, can someone receive, who's not a licensed securities broker, just an ordinary person, receive a finder's fee for referring an investor to securities offering? And the answer right now is no, you can't. The rule is that you have to have a role in management other than raising money, and that's what you get compensated for. And the amount of compensation that you receive can't be related to the amount of money that you've raised. So when I explain it to my clients, I say everybody in management has a role of raising money. They all get compensated for that role or for everything else they do besides that role. So don't pay anybody any amount that's related to the amount of money they've raised. That's going to be viewed as a commission. The only people that can legally earn commissions have to have a securities license. However, there's a recent proposal by the SEC to change that and to allow some finders to so there's a new proposed rule. The public comment period ended November 13th. It would allow unlicensed finders to receive commissions. And, there's two different tiers of the kinds of people that would be allowed to raise. So, you could receive a commission just for being a, one-off, referring investors to a single deal in a 12-month period. That would be okay. Or there would be another level where you would kind of maybe have to go through a registration process and you would be able to refer people to deals on a regular basis. And there's some limitations on what you can and can't do. Still no advertising is allowed.
Yeah, we're going to go through some of the different rules that are going to be allowed and are not allowed. Kim is there to keep you out of jail, and securities laws are very tight laws. And so I want you to do me a favor, if you can, grab a pencil or a pen and a piece of paper and start writing down some of these things, little nuggets, little bullets that I think you're not going to be able to collect everything, but you're going to collect something. And I think that's what the value is of getting together tonight. One of the things that Kim has done and why we like her is that she kind of puts it all down in writing. And if you have a chance, if we'll go do this at the end, maybe Kim can help you get a copy of her book, which how to legally raise private money. We certainly do think that that book is kind of a good place to start when you're thinking about raising money. A good opportunity for you to read that. It's not a thick book. You can read it over a period of maybe a week and just get some general rules and knowledge, kind of rules of the road, as I would say, of understanding securities laws. So when you're raising money, a lot of things that we hear about is a PPM. What is a PPM?
It's a private placement memorandum, and it's the disclosure document that you use to provide the investors with all the material facts that are going to affect their investment decision. So if you're going to be using any non-accredited investors, and we can get into definition of accredited versus non-accredited, but if you're going to have any non-accredited investors in your deal, you are required to have a private placement memorandum that follows the format prescribed by the SEC. And that's going to help those investors make sure that this is an appropriate investment for them, and that they understand the risks of the investment, and that they could lose all or part of their money, and they can't afford to lose the money.
All right, let's talk a little bit about it. One of the things that you mentioned in there is accredited and non-accredited or sophisticated investors. Can you kind of give us some definitions of really what that means? Because if I'm a new person looking to get into multifamily and I don't have the unlimited money that Daryl has, I'm going to have to be able to raise money, and there's going to be certain groups that I can call upon, and there's certain groups that I can't call upon. Can you give me kind of a definition of what that means?
Sure. An accredited investor is someone who has over $1 million net worth, excluding any equity in their primary residence, or they have $200,000 a year income if they're single, $300,000 a year income if they're married. So there's accredited, and then there's non-accredited. But there's a third category, which is called sophisticated. And sophisticated are people who are not accredited, but who have some level of business education or past investing experience that would make them savvy enough to be able to understand the merits and risks of your offering and whether it's appropriate for their portfolio. And they can be sophisticated either on their own or with the help of an investment advisor.
So we are not investment advisors. We are just normal, regular, everyday people. Andrew is going to want to raise money, and he's going to go talk to a bunch of people to raise the money. Should he be looking at a Reg D 504C or a 506B? What's the difference? What all these terms mean?
So Regulation D has arisen from the Securities Act of 1933, which has been amended by rule over many years, and since 1933. And Regulation D is part of that. Under Regulation D, the SEC has promulgated certain rules, and they're saying that if you follow this certain set of rules, then we'll give you an exemption from having to register your offering. Registration means that you would go through the initial public offering process, get approved by the regulators, you'd file an application, you'd actually be taking your company public by getting it pre-approved by regulators before you started offering it to investors. So in real estate, nobody has time to go through the registration process because it's long and expensive. So instead, they qualify for an exemption from registration. So Regulation D lays out the rules of these exemptions. And so there's a Regulation D Rule 504. It's not very much used. It used to only be a $5 million, actually at one point it was a $1 million limit. It got raised to $5 million, and just recently again got raised to $10 million. So it now has a $10 million limit, or it will in the next few weeks, and when that rule becomes effective. So with a Rule 504, the reason it's not very well used is because it requires that you follow the federal rule, but then you also have to get pre-approval by the states before you can sell those securities. So in the alternative to that is Regulation D Rule 506, which has two different parts. And Rule 506 has been around for a very long time, since the 1980s. And the original rule allowed you to raise an unlimited amount of money from an unlimited number of accredited investors. and up to 35 non-accredited but sophisticated investors. But you couldn't do it through any means of general advertising or solicitation. And the way to prove that you didn't advertise was to show that you had a pre-existing substantive relationship with every person who invested in your deal. And pre-existing means it predated your offering. So you didn't have the offering, you had nothing to offer them before, you knew them before that. And substantive means that you already know enough about them to understand whether they're accredited or sophisticated, and to whether or not this is appropriate for them before you make the offer.
Let's talk a little bit about that substantive relationship, because I think that's an important thing that comes up when Trevor Thompson is out having a cocktail, and he's at the cocktail party, and he happens to talk a little bit about an opportunity that he's come across that he wants to have you invest in. If Trevor's just met you, can he start talking about that opportunity right from the beginning?
Technically, well, it depends, okay? Because under Rule 506, there's two rules, actually. It was originally this just one Rule 506, and then with the Jobs Act that came out in 2012 and then finally got approved in 2013, where the rule was split into two parts. So 506B is the old rule. That's the one I just gave you the rules for. 506C is kind of a corollary to that. It allows you to raise an unlimited amount of money from an unlimited number of verified accredited investors, and you can freely advertise. So you really have two options under Rule 506. You can freely advertise, but you're restricted to verified accredited investors, meaning they have to go through a verification process to prove they're accredited. Or you can stick with the original friends and family rule, which was the Rule 506B. And that's the rule that allows you to bring in non-accredited investors. And the other part of Rule 506B is that the investors don't have to go through a verification process. They can self-certify. And they do that by filling out a subscription agreement that explains their financial qualifications and sophistication.
Federal laws versus state laws, like we talked about a little bit. You're not a transactional attorney. You are a securities attorney, really specializing in the rules for securities being purchased. Tell me a little bit more about, if I live in Texas and I am an investor and I want you to invest in a deal that I'm bringing to the market, but you live in California, are you able to go over state lines to solicit in California?
So that's the beauty of Rule 506, and it is by far the most widely used exemption that there is. Over 25,000 Rule 506 offerings are offered every year in the United States. The thing about Rule 506 that makes it so popular is that it preempts all the individual state laws. So you don't have to go for approval from a state before you can offer it to people in that state. You do have to do a notice filing in that state. So for all these exemptions, in addition to following the rules that I laid out, you have to do some notice filings with the SEC claiming that you're, which exemption you're claiming, 506B, 506C, or some other exemption. And then when you do bring in investors from states, then you also have to notify the state securities agencies. And you usually only have 15 days from the date that you accept funds from that investor, those funds, when those funds become irrevocably contractually committed. At that point, you have 15 days to notify that state that you sold securities in that jurisdiction, but you only notify them one time per state, regardless of how many investors come from that state.
So if you live in California and you are thinking about investing in Texas or in Indiana or 49 of the other different states, that syndicator has got to kind of what we call that blue sky law or so for you. Right. In every state. And so that is, if you're a syndicator, that can be expensive if you're taking money over certain different lines, and maybe $300 here and $200 there on every time that you take money in from different people that are investors in your deal in different states. So that's something to realize, is that when you start talking with folks to solicit to bring more money into your deal, you're starting to wave the banner that this deal is coming together and you want to start looking for money. If you start going over different state lines, you're going to have to make sure that you pay all those additional fees that you forgot to, or you didn't remember that state was going to charge you.
Yeah, and typically for say like a $1 to $5 million raise, you could expect another $3,000 or $4,000 in filing fees, which would cover both your LLC formation costs or your limited partnership formation costs, as well as your securities notice filings for a raise of that size. If the raise gets bigger, you might be bringing in people from additional states. But also be aware that the Northeast states are the most expensive. Florida has no filing fee. In New York, the fee can be as much as $1,900. Massachusetts, it can be as much as $750. So you just have to be careful because those fees do kind of start to add up.
All right. So the question I get the most often is, I guess this would be from Izzy. Izzy says, I have a lot of friends, but how do I determine whether they should be investing in my deal or not? Do I need a PPM? Do I need a business plan? Am I a financial fiduciary on behalf of the partnership? Tell me a little bit more about what role do, say, general partners play in a syndication?
Yeah, so the general partners, so in a limited partnership, you have general partners who are the management team, and then you have limited partners who are typically the investors. In an LLC, you have a manager, which is the same role as the general partner, and you have members, which is the same role as the limited partners. So it just depends which entity you're looking for. But in either case, the management team, if you're selling securities, then you are taking on a fiduciary responsibility for those funds of your investors. And that really means that you have to place their interests ahead of your own. And you have to make sure that you're acting in their best interests at all times and acting to the best of your ability and normal business practices and all of that. So you really do have to think about that when you're handling other people's money.
I am thinking that Savannah Royal is thinking, where do I get you involved in this transaction? Do I get you in before I even find a deal? Do I get you in when I find a deal? What's the best time to get Kim involved in these transactions?
So certainly we recommend that you hire us to start drafting your offering documents at the point that you have a deal under contract. So you have a signed purchase agreement, someone from your team has physically been to the site, and you reviewed the financials. So once you've done those three things, we believe that's the time to hire us, because it takes 2 to 4 weeks to get your offering documents completed from the time you hire until the time you have final offering documents in hand and you're ready to go out and start raising money. And you want that to happen so that it coincides with the end of your due diligence period. So your offering documents and your due diligence period are over. From that point on, you really should be just raising the money and dealing with the processing of your bank loan.
So any words of advice? Syndications are a bunch of people coming together and putting their own money into the transaction. Any words of advice to somebody that's, say, brand new, that doesn't know anybody, doesn't know where to get the money to do it? You've talked with a lot of successful syndicators. How have they done in the past? How do they go out and meet people that want to invest in their business?
Well, groups like this are a perfect example. Of course, back when we used to be able to do live meetings, that was a perfect place to go. Any kind of events where you can go, where that you can meet people face to face, and if now we don't have the ability to meet in person, Zoom is best, not necessarily Zoom, but something where you get to see each other's faces and speak to each other is better than just a phone call. So, any local organizations that you're a member of, I like to say, find your investors locally, but invest globally or nationally, because your investors that you can meet through your church or any kind of local real estate investment associations or Chamber of Commerce or any other kind of civic organizations that you're a member of are going to be people that are going to know you as a member of the community, and they're going to trust you, and they're going to be your best investors. And those are the investors that will stay with you for a long time.
Before I shut up here in a few minutes, I want to make sure that everybody has a chance to get their question answered by Kim. I want to make sure that, you're not going to get charged for the question. If you want to grab a relationship with her down the road, but this is a good opportunity to throw out a question so we can get that answered with everybody. So there's never a dumb question when it comes to this type of stuff. This is a little bit more complicated than most parts of the transaction. So, but this is the most important one, because you can get in trouble if you're raising money the wrong way, you're collecting money the wrong way. And so can you give me maybe the top 5 things that new syndicators do that can jeopardize the transaction, jeopardize them. Give me some basics.
So number one is that I see a lot of new syndicators going out and looking for big investors, and that is always a mistake. I have been doing this for over 12 years. I've been the responsible attorney for hundreds of securities offerings, and I've probably only ever seen that come to fruition a handful, like 5 times. All the rest of the times, the single investor is usually too polite to say no. They string you along, and then all of a sudden, towards the end, when you're ready to close on the deal, something came up. They aren't able to invest after all. You're left holding the bag, and you've spent a lot of money on pre-closing expenses that you can't get back. So the right answer is always to go out and raise your money from $50,000 and $100,000 investors. Start with people. If you don't have any experience at all, you have to start with people you know, because they're not going to ask you about your experience. Hopefully they already know you and believe in you, and they'll invest with you anyway. If you want to start advertising, then you need to have a track record, because the first thing a stranger is going to ask you is, well, how many times have you done this? So that's a big thing. Make sure that you pick your management team very carefully. More than 5 people on a management team is a death now. I have seen that happen way too many times, that more than 5 people cannot agree all the way to the closing table. And usually somebody ends up leaving, but it's not without some amount of grief. And sometimes they end up going all the way through and then ending up in litigation afterwards. So don't make your management team so big that you can't manage it. And make sure that the people that you're inviting into your management team have clearly defined roles. And they're not all doing the same thing. They should all be doing, specific things that they have skills for. So, look for complementary skill sets to build your management team.
So before we started to talk, Rob Durrett said that he's kind of brand new to the multifamily business, but he wants to raise capital. Again, he's got to meet somebody like Daryl Murphy, because again, he has unlimited capital. So again, Daryl, thank you for the opportunity for us to knock on your door to get your unlimited capital. But Rob, he doesn't have a track record. I mean, how does he do this? I mean, how many times have you done that? That's the question that's going to come up from his friends, and prove to me that I'm not going to be throwing away $100,000. How do you get around that question, or how do you get through that question, or how do you answer that question?
You bring in someone into your management team that has that experience. Your first few deals, you need to team with experienced syndicators and that are buying the kind of assets that you're buying. So if you're going to do multifamily, don't hook up with people that have self-storage experience. Get other people with multifamily experience on your team. And you may have to give up a big chunk of that deal, or just take a small piece, even if it's your deal, just to make sure that you bring those people on. Same thing with bringing in money. If you don't know people, then one of the people on your management team should be somebody with a big Rolodex, I guess, showing my age there, right? A big database, shall we say, in today's world.
A big database.
Yeah.
So I think Melanie has this thinking in her mind. I think this is a great idea. Use other people's money, be a fiduciary for other people's money, whether it's my brothers or sisters or my best friends. I want to make sure that I'm doing the right thing for that. But I also want to be compensated. So how do syndicators make money in this business?
Well, so you'll usually create a company. So it's either going to be an LLC or limited partnership. 99% of the time, you're going to use a limited liability company, an LLC, versus a limited partnership. The only time you would use a limited partnership would be if you're bringing in non-US investors into your deal, and it would be advantageous for them. So you're going to use an LLC. As you're setting up your LLC, you're going to keep a portion of the ownership for yourself, for your management team. So you're only going to sell off a portion of those interests. So maybe you give 70% to the investors. So they're going to put up 100% of the money, but they're only going to own 70% of the company. The other 30% is retained for management. Additionally, the management team will earn fees for the active role in management. So that could be an acquisition fee, 1 to 3% of the purchase price, asset management fee, 1 to 2% of the gross collected income that's collected annually or monthly or quarterly. You could get a refinance fee, you could get a loan guarantor fee, maybe a disposition fee. It's kind of an a la carte menu, don't feel like you guys have to write all this down. I can direct you towards the end on where you can get all this information. But that's, so you're going to get fees and you're going to get a share of the profits. And the share of the profits is where you're going to make the bulk of your money. The fees are going to be, keep you alive and walking around until you get to the point of sale, which is going to be several years down the road.
Yeah. 2 last questions before I start to take questions from the audience. Again, put your questions into the chat and I'll try to get to as many as I can. Can you advertise on Facebook and LinkedIn?
If you're doing a Regulation D Rule 506C offering, yes, you can. But remember that all your investors can only be accredited. So they have to be verified accredited investors. So yes, if you do a 506C offering. No, if you do a 506B offering, that's a word of mouth offering, one-on-one. You should not be publicizing that in any way.
Tom out of Knoxville says, hey, listen, if I wanted to attract investors' money, do I have to pay a preferred rate of return? Right now, 8 or 9% attracts capital or cash into these deals. Tom says, I don't really want to pay a preferred rate of return. And so what are you seeing right now, Kim? Are you seeing a lot of syndicators paying a preferred rate of return in these transactions?
Most of them still are, but I'm starting to see some trends away from that. I'm actually speaking on a panel at an IMM conference in a week or so, and actually I'm moderating that panel. And the panel, one of the panelists said, we're not doing preferred returns anymore. And they have a very large fund. I have some very experienced clients that are trying to get away from the preferred returns because those can really kill the deals and cause the investors to receive all of the funds and you to get very little except for your fees. And you're taking on a lot of risk, so you need to be well compensated for it.
Yeah, preferred rates of return right now are really going away, and they've been going away for the last 5 or 6 years where the yields have started to come down significantly. Mm-hmm. If you got into if you were a syndicator and you funded a transaction and you funded the transaction with the belief to the investors that you were going to pay them 8%, and that if that 8% was not going to be available, then next month, if that was available, you'd have to pay it. If you didn't, you'd have to go the next month. If you didn't, you have to go the next month, and all of a sudden you're starting to dig a hole in your backyard, because at some period of time you're going to have to catch up with the investors that were been promised or guaranteed to get an 8% rate of return on their money, so to speak. And so that becomes very difficult. And what happens is that what we see between the limited partners and the general partners, the confidence starts to go away in that, and that the monies that the general partner thought they were getting are not going to be coming there anymore. So the general partner starts to walk away from the deal. So be very careful with a preferred rates of return. Yes, it's sometimes good as a worm on a hook to try to attract investors to see it. But if you're a syndicator, sometimes it's difficult these days where you think that you can get an 8% rate of return on a come in and come out type of a deal. It is very difficult these days to get anybody to do that with these Class B and C properties. A question that came up I thought was good from Tony, who's looking to be a GP in Oklahoma and Phoenix and Texas. Once you've created a PPM, Kim, how long do you have to raise the funds?
So a typical anatomy of a deal is if you can get a 90-day escrow period, that's ideal. If you can't, get a 60-day with a 30-day extension. Okay, because it's very hard to syndicate anything in less than 90 days, unless you've raised the money in advance, and meaning that you have, friends and family waiting to give you, whatever money you need. So try to get a 90-day escrow period. You're going to be, raising the money for about the last 45 days of that, 45 to 60 days of that. And you're really going to start raising the money as soon as you get the property under contract. Don't talk to people about deals until you have a signed purchase agreement, because somebody will figure out where the deal is and they will take it from you. I've seen it happen. Yeah. So just beware of that. Until then, you're just having a general conversation that you're a syndicator, you're putting together deals and you're looking at deals all the time. And that's how you develop these relationships, with that kind of a general conversation. And then after you have the relationship and you've documented that you have the relationship, then at that point you can start offering specific deals.
That's that substantive relationship that you must have before you can bring an opportunity for somebody to invest in that deal. Again, as you know, I've done a lot of multifamily transactions over my 36 years. And one of the things is that if you're brand new and this is kind of your first deal, your second deal, it is like ice skating. So Jim Briggs would know. Jim, who used to be a good ice skater up in Chicago, when you first put the skates on, it is a little wobbly. You're going back and forth. And it may take you a lot more phone calls than you think to raise $2 million for your syndication. So if you're raising $2 million, look to raise $4 million because you're going to have 50% of the people that are going to fall out off the map once you, they all say yes, yes, yes. And all of a sudden they're just going to say, I can't come up with $100,000. I can't even do $50,000. So make sure that in your mind, you're doubling the amount of respected investors to put money into these transactions. And then the more you do, the better you're going to become a skater. And then you're able to skate backwards. And so, as you know, I do a podcast with Michael Becker. Michael just is going to close on a transaction next week for $60 million. Now, this is his 37th transaction. He had to raise $20 million or so, and he did it in a matter of like 3 days. So, yeah, you get better over a period of time. So just think that this is a skill that you can get much, much better at. And it may feel wobbly at first, but then you can do much more stuff. Carrie from Houston and looking to invest in Austin, which is a very hot market. Look for a 3% cap rate in Austin. When should I consider a JV versus syndication? At what point does a syndication make sense?
That's a really, really great question. Thank you for asking it. The definition of a joint venture is that everyone has an active role in management. Every person in the deal has an active role in management. So the first question is, how many people do you think you can have having an active role in management and maintain your sanity? So usually that's about 4 or 5. So we're back to that 5-person rule in a joint venture. More than that, you're going to start to have dissension and people who don't agree. And it's going to be hard to get things done, or you're going to end up with disgruntled people. And those should be people that you know very well if you're going to do that joint venture. So, once you pass into the role of, either people don't want to be actively involved because they're busy and they have jobs and lives and they don't have time, or you just don't want to have that, you're going to need more people than that and it's not going to be practical, then you're really in the realm of selling passive interests to people. And that maybe is one of the things we kind of skipped over that perhaps we want to go back to, Paul, is, what is a security? When do we know if we're selling securities? So if you have an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter, then you are selling, the promoter is the one who's selling the securities. So in layman's terms, if you have passive investors that are relying on you to generate a profit for them, then you're selling securities to those people. And then translate that into what does that mean for me? If you're selling interests in an LLC, it's a manager managed LLC. You're going to be the manager or part of the management team. These other investors are going to be passive. Then you are selling securities to those passive investors. Same with limited partnership interests. By definition, where the investor or the limited partners invest money, you're selling securities. So when you sell securities, you either have to register the offering or qualify for an exemption from registration. And that's where we started talking about Rule 506 and 504.
So fantastic. I can listen to you, Kim, all night because I love this business because it keeps me out of jail. And that's the biggest thing that Mrs. Peebles is all concerned about is me staying out of jail after 26, 27 years of marriage. She doesn't want me to have a problem. So just a couple more questions and we'll get to the fun part. And that's kind of the breakout rooms. Again, I'm not good at this, but hopefully I'm going to keep my fingers crossed that I can do the breakout rooms. But a couple of things that had come up with, Peter Pomeroy had a good question. Do some syndicators only allow U.S. citizens to invest? What happens if I have somebody from Canada or Hong Kong or Taiwan? What's the rules with just having U.S. citizens, or can I have international investors too?
So there is a separate exemption for international investors. So this other exemption is called Regulation S like Sam, and it applies when these investors are not U.S. persons, meaning they're not citizens, legal residents, and they're not living in the U.S., and they're wiring their funds from an offshore account. So if those things are true, then those are non-US investors and they can invest under Regulation S. But you would have to know in advance that you're going to have those investors invest with you for two reasons. One, we have to make sure that we put the right provisions into the offering documents for you and make sure that you have the right offering documents for those non-US investors. They're going to have a different subscription agreement. They may actually even need a separate private placement memorandum. If you're doing an advertised offering, you'd have to separate and have two separate private placement memorandums. If you're doing a non-advertised offering, we could just incorporate it into the regular PPM. You also need to vet those investors. So you really need to know who they are, because you want to make sure that they're not using you for some money laundering purposes or something like that. There are anti-money laundering laws that you have to follow. And there's also tax issues involved with bringing in those investors. So if you're bringing investors from another country into your deal as an equity investor, then you will have to withhold taxes from them and send it to the IRS before you could send their distributions outside the country. And if you do it wrong, the person who signs the check remains personally and primarily responsible for payment of their tax. So you would send, it's just like a payroll withholding. You would send the withholding amount to the IRS. And then if they were wanting to see if they were entitled to a refund, they would have to file their own US income tax returns. Many investors don't want to do that because it could subject some of their worldwide income to US taxation. So there's always a balance that has to be met there. This is why you might hear something about using blocker companies if an outside of the US, where the non-US investor would invest in a blocker company. That company would make the investment in the US, kind of keeping a separation between them and the US. The other thing you need to know is that other countries also have securities laws. So if you're going to have somebody in those countries soliciting investors for you, then you have to make sure that you're doing it legally in their country.
Makes sense. All right. Doug Tran had a question out of Houston. He's looking to be a general partner. He thought this was a good question. I do too. Can a project switch from a 506C to a 506B?
Well, not really. You could stop your 506C offering. You could start a separate 506B offering. But if you've already advertised for investors and you've already gotten investors from those ads, then you wouldn't be able to have them in a 506B offering. So you would actually have to have a separate offering for them.
And because Daryl has nothing but money, we always enjoy listening to Daryl in the way that he has unlimited capital. My question, this is my last question. Give us an idea from a low to a high, what a cost would be for a securities attorney to, and again, generalization, what it would cost to put together a PPM and represent an entity that wants to buy an apartment building.
So our typical fees for doing what's called a specified offering, where you've got a deal under contract, you're raising money for one specific property. Typical fees for that are $12,500, but then you should expect to have another $2,000 to $4,000 in those filing fees we talked about earlier. So if you budget 15, you're going to be really close to the ballpark there. So if you put that into your budget, it'll be good.
That sounds reasonable. That makes sense. There's a lot of attorneys that will do it for a lot more money, but I think Kim and her group you'd want to talk to see. Again, she's the one who wrote the book. If somebody wanted to get more information about possibly working with you in the future or get a copy of this great book, is this on Amazon, or how do they get copies of this?
So that is a #1 Amazon bestseller. You can buy it on Amazon if you like, or if you'd like to get a free copy of it at our website, you can get a digital copy there. You can read it online. So the website is syndicationattorneys.com. While you're there, I would also invite you to review our library. We have a very extensive library there with over 40 articles. We also do a free monthly teleseminar, and we've been doing it for over 3 years and recording them and posting them on our website. So each month I either teach a subject or we interview someone with a service related to syndication. So maybe we need to have Old Capital on there, I think. Anyway, there's a lot, and there's also frequently asked questions. I would also encourage you to read the frequently asked questions, because those are the things I get asked all the time. But if you want to, in a nutshell, read the book. I've had some people say they've read it in one sitting. So I consider it a 2-flight book.
I do too. It's very good.
Anyway, yeah, we would love to have you, join our teleseminars, and we do have a way that if you don't have a deal under contract, we have a kind of a nominal cost way for you to become a client. And once you become a client, then we will give you some perks and also invite you to attend our syndication masterminds, which we're currently doing weekly.
Perks, is that like a free cup of coffee?
Free stuff. So we'll give you a free investor marketing plan template. And so for $1,000, we have a pre-syndication retainer. Gives you up to 3 hours of one-on-one advice with either me or my other securities attorney. And also gives you the investor marketing plan template, an investor relations blueprint, invitation to our syndication masterminds, and a discount off your first syndication equal to or greater than the amount that you paid for the year.
All right. So Kim, a lot of people did not write this down, but now they've grabbed their pen and their piece of paper. Can you give them again the website again, so how they can get that free book?
Mm-hmm. Go to syndicationattorneys.com.
Syndicationsattorney.com.
Syndicationattorneys.com.
Well, yeah. So that's perfect. And a big round of applause for Kim. Thank you very much. We certainly do appreciate you. Thank you. Very nice. It's